Good afternoon and welcome to the Heritage Foundation, specifically to our Douglas and Sarah Allison Auditorium. We, of course, welcome those who join us on our heritage.org website on all of these occasions. For those of you in-house, your assignment, of course, is to make that courtesy check that cell phones have been silenced as we prepare to begin. And, of course, we will post the program on the Heritage homepage following the presentations for everyone's future reference. As part of this series, we are also reintroducing to everyone Heritage's Guide to the Constitution. We'll have copies available if you would like to purchase them. It is a unique discussion of each clause-by-clause analysis of the Constitution, updated with many of the more recent court cases since its initial publication. Hosting our discussion this afternoon is Andrew Kloster, who is our legal fellow in the Edwin Meese Center for Legal and Judicial Studies. He focuses on civil rights, the role of federal courts, and other constitutional issues. Before joining us here at Heritage, he was the Justice Robert H. Jackson Legal Fellow at the Foundation for Individual Rights in Education. He has also worked on Capitol Hill and with a human rights organization at the United Nations. Please join me in welcoming Andrew Kloster. Andrew?
Thank you. So today is the fourth event in our Preserve the Constitution series, and we have 3 events remaining, including our Joseph Story Distinguished Lecture, which this year will be Judge Bea of the Ninth Circuit. So this event, today's event, and the prior events and the future events, they're all online. I hope they'll be a great resource going forward. Our Preserve the Constitution series is a marquee event every year here at the Legal Center. You might ask, what does campus sexual assault have to do with the Constitution? And I wouldn't blame you if you asked that question, but the answer is a lot. I'll leave most of the time for our panelists, whom I will introduce in a moment, and I'd like to leave ample time for questions, but briefly, the Constitution comes into play in at least 3 ways. First, education policy and crime policy are generally under the Constitution within the state police powers. It's only through federal grants and non-discrimination law, a non-discrimination law called Title IX, that the feds are able to regulate in this area at all. Perhaps 80 years ago, colleges were little fiefdoms with all-powerful college presidents that could expel a student on a moment's notice or place them on double-secret probation for violating unspoken rules of campus culture, but no longer. Today, there's a massive regulatory apparatus, and Washington, D.C. sets the culture, which leads to the second quasi-constitutional aspect of this subject, administrative law. Title IX is short and is simply a prohibition on sex discrimination in educational programs that receive federal funding. It's only through a series of court cases and regulatory guidance that flesh is put on these bones, and the one line of Title IX spawns entire tomes of regulatory guidance, including now to tell universities precisely how to micromanage their disciplinary proceedings. We might have to wait for a new administration and newly staffed Department of Education to correct some errors and provide clarification, but perhaps there are things that Congress could be doing now to help. In addition to being dubious on substance, this regulatory guidance, particularly under the Obama administration, has been issued aggressively and in a fly-by-night fashion, without notice and comment generally required by federal law, and without input of all stakeholders. This iron triangle of federal bureaucrats, non-academic college administrators, activists, and money-hungry compliance trainers ensures that among the goals of universities, education ranks a distant second. The final constitutional issue is perhaps the most important, the First Amendment and due process rights of students and professors that they ought to be guaranteed. These constitutional values are often lost in the shuffle when serious allegations are made. In the criminal justice system, to paraphrase a man for all seasons, this country is planted thick with laws from coast to coast, man's laws, not God's, and these laws protect the accused. And yet when allegations of felonious behavior are leveled on a college campus, suddenly we cut these laws down, flip the presumption of innocence on its head, and take casualties of defective process as the cost of doing business. And we've had numerous fiascos, which I'm sure will be mentioned today, UVA and the Rolling Stone hoax, the Duke lacrosse hoax, the fire case of Caleb Warner at the University of North Dakota, and the list goes on. So I will just preface this discussion with the following disclaimer and trigger warning. First, sexual assault is an incredibly serious crime that should be treated as such, and each of our panelists and myself, we will do so. But second, trigger warning, this discussion will include a frank discussion of facts and evidence, and it might challenge your political assumptions. If you are triggered by having your opinion challenged, I would suggest that you listen in because it might do you some good. So without further ado, I'll introduce our panelists in the order in which they will speak. First is Samantha Harris. She is the Director of Policy Research at the Philadelphia-based Foundation for Individual Rights and Education. In that capacity, she's one of the leading experts in the country on campus speech codes, and her FIRE bio notes that, quote, while she may not be able to name your university's sports team, she will definitely be able to tell you about their harassment policy. And as an aside, FIRE rates Harvard a red light in speech codes, and they are the Crimsons, so in that case, the two dovetail. She holds a JD from the University of Pennsylvania Law School. Next is Casey Johnson. He is a history professor at Brooklyn College and the City University of New York Graduate Center. He holds a PhD from Harvard University and is the author, along with Stuart Taylor, of Until Proven Innocent, Political Correctness and the Shameful Injustices of the Duke Lacrosse Rape Case. He's a frequent columnist and commentator on education policy, and in particular on the subject of today's discussion. Finally, we have Heather McDonald. She is the Thomas W. Smith Fellow at the Manhattan-based Manhattan Institute and a contributing editor of City Journal. She is a recipient, the 2005 recipient of the Bradley Prize. McDonald's work at City Journal has canvassed a range of topics, including higher education, immigration, policing, racial profiling, homelessness and homeless advocacy, criminal justice reform, and race relations. Her writing has appeared in the Wall Street Journal, Washington Post, New York Times, LA Times, New Republic, et cetera, et cetera. She holds a JD from the Stanford University Law School. So I think we have a great panel lined up for today. I hope we have ample time for questions. And with that, Samantha?
Thanks, Andrew. So, can everyone hear me? Yeah, okay. So, since FIRE's inception in 1999, students and faculty have complained about the issue of lack of due process in campus proceedings. That's always been on FIRE's radar screen. We deal with individual rights on campus. For many years, the mainstay of our work has been free speech and censorship on campus. But in the last 5 years, thanks to unprecedented intrusion by the federal government, the situation regarding due process on campus has gotten markedly worse. Specifically, students facing allegations of sexual misconduct are routinely found responsible and expelled without a hearing or an opportunity to meaningfully confront their accuser. Things have gotten so bad that since 2011, which, as I'll get into, was the year that the government really issued its first piece of guidance that marked the massive intrusion that I'm talking about, more than 60 students have filed lawsuits alleging that they were denied fundamental fairness in campus sexual assault proceedings. And since I wrote more than 60, there have been 2 or 3 more filed. I mean, these things are coming in to the courts, on a weekly basis at this point. So since I'm speaking first, I want to spend just a minute talking about how we got here, and then I'm going to talk a little bit about some of these cases and what we can learn from them about students' due process rights and how students who feel that they have been treated unfairly might proceed. So one of the first questions people always ask me when I talk to the general public about this topic is, why are colleges handling rape cases? It's a crime. Shouldn't that be a police matter? The short answer, as Andrew mentioned, is Title IX. Title IX itself does nothing more than prohibit sex discrimination in higher education. But over the years, courts and administrative agencies have expanded the meaning of discrimination to include sexual harassment and sexual violence, including student-on-student sexual harassment and sexual violence. In April 2011, the Department of Education's Office for Civil Rights, or OCR, was what I'll call them going forward, which is the administrative agency that oversees the implementation of Title IX on campus, issued a groundbreaking Dear Colleague letter that inserted the agency directly into the minutia of campus sexual assault proceedings. In that letter, OCR mandated that in order to comply with Title IX, schools must use a preponderance of the evidence, which is a more likely than not standard to adjudicate claims of sexual misconduct. This was required even if the university was using a higher standard of evidence to adjudicate other claims of misconduct. OCR also strongly discouraged schools from allowing parties to personally cross-examine each other, despite the fact that cross-examination has been called the greatest legal engine ever invented for the discovery of truth. At the same time, OCR dramatically ramped up its investigations of alleged Title IX violations, and these investigations can ultimately culminate in a loss of federal funding if an institution is found to be out of compliance with Title IX. In May of 2014, which was the first time that OCR went public with the number of schools under investigation, the number was 55. By August of 2015, 128 schools were under investigation, and I would be surprised if that number were not even higher today. So this 1-2 punch by the federal government has led many universities to abandon critical due process protections for students accused of sexual misconduct. And as an aside, as Andrew kind of hinted, there's a strong possibility that OCR's guidance here violated the Administrative Procedure Act because it requires, the Administrative Procedure Act requires that new administrative requirements generally have to be subject to notice and comment, which these were not. And that's something I'm not going to get into too much right now, but I'm happy to answer questions about or talk more about later. So accused students, as I said, have begun suing their universities in court over these due process violations. And even though the facts of these cases often seem outrageous, they've so far proven to be an uphill battle for the plaintiffs. But that said, there have been some important victories for students seeking due process rights, and some important trends have kind of emerged that offer some good insight into how future plaintiffs in these cases might proceed. The most favorable decisions so far have come from state courts. In some states, the state courts are authorized to overturn decisions of state university judiciaries if they are demonstrably unfair. This happened recently in a case at the University of California, San Diego, where a judge overturned a finding of responsibility because he was troubled by a lack of meaningful cross-examination. The plaintiff was only allowed to cross-examine through the hearing officer, which is what OCR has recommended. They don't want this direct cross-examination, but the hearing officer asked only 9 of the 32 questions submitted by the plaintiffs. The court also found that the university improperly delegated the duty to render a decision to a single investigator. And this is something that's important because the single investigator model, which is basically where one person investigates a case, speaks to the parties, and renders a decision without a hearing, that model is quickly gaining popularity on campus and has been praised by the Obama administration's task force to protect students from sexual assault. And in Tennessee, a state court judge overturned a guilty finding at the University of Tennessee, Chattanooga, because the judge ruled that the school's use of an affirmative consent standard effectively required the accused student to prove his innocence. Affirmative consent standards, which are becoming very widespread on college campuses, generally they define consent not as the absence of a no, but as the presence of a yes, which sort of shifts the burden of proof to the accused to prove that there was consent. So these state decisions are encouraging, but the majority of the plaintiffs so far have brought their suits in federal court. These federal lawsuits generally claim one or more of these 3 things, usually all. One is Title IX sex discrimination, so that is that the male students are alleging that the unfair disciplinary proceedings discriminate against them on the basis of sex. Another claim students at state universities make is that the university's procedures violated their constitutional due process rights. And students at both public and private universities allege that there's been a breach of contract, that the school's use of an unfair procedure violated a contract with the student, as set out in the student handbook and other documents. So the Title IX claims, as I said, allege that the university's investigation or disciplinary proceedings were biased against the accused student on the basis of sex. The big challenge for these plaintiffs is that they have to offer evidence of actual gender bias rather than evidence of a bias against the accused more generally. And this is where things get tougher. I mean, it's pretty easy in a lot of cases to show facts that evince a bias against the accused, but as one court noted when it dismissed a plaintiff's Title IX claim, there may be totally non-gender related reasons for a university to be biased against accused students, such as a fear of negative publicity or a fear of Title IX liability. Many of these claims have not yet been ruled on, but most of the ones to be decided so far have been dismissed in the early stages of litigation. The ones that have survived are the ones where the plaintiff has offered some concrete evidence of not just a bias against accused students, but also a bias specifically against male students. So in a case against Washington and Lee University that recently survived a motion to dismiss, the plaintiff offered evidence that the university's Title IX coordinator, who was responsible for overseeing the proceeding, had spoken favorably about an article claiming that sexual assault occurs whenever a woman has consensual sex with a man and regrets it because she has internal reservations that she did not outwardly express. So the court accepted that, that the Title IX coordinator had spoken favorably about that article as evidence that there might actually be gender bias. But in most of the cases, what the judges have ruled is, look, the plaintiff has come forward with some evidence that the university's proceedings may be biased against accused students, but they haven't taken that next step and shown that it's on the basis of gender. Plaintiffs at public universities have also brought Section 1983 claims alleging violations of their constitutional due process rights. Section 1983 is a federal law that allows people to sue, governmental agencies, including state university, employees of governmental agencies, including state university administrators, for depriving them of constitutional rights while acting pursuant to their official duties. So these claims kind of sound like a natural fit, but the federal courts have generally been pretty reluctant to insert themselves into universities' internal decision-making processes, except when the due process violations have been particularly egregious. So courts have allowed a few of these kinds of claims to proceed, but generally on very narrow grounds. And if you were to read the opinions, things that might sound outwardly like pretty serious due process violations don't rise to the level of what the court would consider a constitutional due process violation in the university setting. Because although public university students do have constitutional due process rights, they're not the same rights that people have in the criminal courts. So they include notice and an opportunity to be heard, but courts have taken a pretty broad view of what that looks like. And have sort of accepted a wide range of university disciplinary proceedings as sufficient notice and opportunity to be heard. And then at private universities, where students don't have constitutional due process rights, a number of students have brought these breach of contract suits. If a university disregards its own written procedures, there may be a claim for breach of contract, because in many states, if not most, courts have held that university handbooks and other policy documents do constitute some form of contract between the student and the university. Now, most of these claims have been unsuccessful because the problem in most of these cases is not that the university didn't follow its own procedures, which is what you have to show for a breach of contract claim, but rather that the university's procedures are simply unfair. And there's not a breach of contract claim based on the sort of inherent unfairness of the procedures if the procedures are written and the university followed those procedures. The situation in federal courts has been pretty tough for these plaintiffs, and it seems like the best bet right now is, for public university students at least, is in state courts, particularly where the courts have some sort of authorization to overturn university judicial findings on grounds of unfairness. But this area of the law is very rapidly evolving. So just a few weeks ago, after I wrote this speech and after I wrote the article that some of you may have seen that accompanies it, a federal judge enjoined Middlebury College from expelling a student accused of sexual assault, which, to the great outrage of the Middlebury student paper, which published this editorial railing against the idea that Middlebury's internal judicial processes should have to be limited by the law. With a number of pending cases, I'm sure that there are going to be more rulings on this in the year or weeks and months and the years to come, and I think that this area of the law will continue to be fleshed out. But overall, whether the rulings have been favorable or unfavorable, what we've seen so far is that the rulings have been highly specific to the facts of each case. So while individual plaintiffs might have luck in the courts, solving the larger due process crisis on campus is probably going to require a non-judicial solution. First and foremost, OCR has to be reined in. I mean, their overreach here and its impact on universities and the way that they handle these cases almost can't be overstated. Federal and state legislators can also take steps to protect students' due process rights. North Carolina and North Dakota have both passed right to counsel legislation, which guarantees public university students in those states the right to hire a lawyer who can actively participate in campus disciplinary proceedings. And there have been a few bills recently introduced in Congress that would also shore up students' due process rights by securing the right to counsel, and also by requiring, among other things, that universities disclose exculpatory evidence to accused students, which is something right now that does not always happen. And finally, defenders of student due process rights have to be willing to speak up, despite the name-calling that often accompanies advocacy in sexual assault cases. From my time speaking out on this issue, the one thing I've come to realize is that a number of otherwise progressive people who care deeply about justice and the rights of the accused seem to have developed a real blind spot when it comes to sexual assault, where there seems to be this blanket presumption of guilt and this presumption of guilt by association applied to anyone who suggests that people accused of these kinds of offenses have to be treated fairly. So I think that all of those are things that need to happen, in addition to these court cases that are going on, for there to be sort of meaningful progress on this issue and for the pendulum to start swinging back in the other direction towards more fair campus procedures. Thanks.
All right, so I'm going to speak on the university side of things, and I struggle to come up with any contemporary public policy issue which has been as poorly covered in the media, with a couple of exceptions in the second row here, as the appropriate university attitudes towards campus sexual assault. And the problem really rests on two, I think, erroneous myths. So erroneous myth one is the following: that amidst a wave of violent crime on campus, indeed according to the administration and to activists, the typical female college student has a greater risk of being a victim of violent crime today than the typical resident of Detroit, Memphis, and Oakland, which the FBI lists as the three most dangerous cities in the country. Amidst this violent crime wave, university administrators and the broader campus culture in which they operate have been at best indifferent to, and at worst outright hostile to the student victims in their midst, and indeed have structured procedures that favor the accused in sexual assault cases, and that fact, I put in quotes, has justified this extraordinary intervention by OCR, the radical reinterpretation of Title IX to give the federal government authority to dictate specific procedures that universities must follow in sexual assault cases, each of which, as come from OCR, are designed to make it likely, and in some cases far more likely, that university disciplinary processes will lead to guilty findings. This is a vision of the university campus culture which anyone who has spent more than 3 seconds on a college campus today would find hard to reconcile with what they've experienced. And in particular is hard to reconcile with a few broad facts. The first is that in the last decade, as Andrew mentioned in his opening remarks, the two most significant, the two highest profile rape hoaxes in the United States have occurred on college campuses. The first was the Duke lacrosse case in 2006. The second was the UVA Rolling Stone case in 2014. In both of these cases, the university administration, the outspoken voices among the university faculty, and in the UVA case, to their great shame, the student government and the student newspaper rushed to side with the accusers, not with the accused, did so publicly, consistently, despite the enormous holes in the credibility of the accusers in both cases. Crystal Mangum, the Duke case, who never told the same story twice, and the anonymous Jackie in the UVA case, who alleged this lengthy gang rape in which she was raped on shards of glass but somehow was left physically uninjured by the assault. And this reaction is not at all surprising. It reflects a broader change, particularly a pedagogical change among the faculty in the last generation to 2 generations, the extremely large growth of faculty specialists in themes of race, class, and gender, people whose pedagogy depends on the perceived existence of an American society that is deeply oppressive on matters of race, class, and in this case, gender. And so in seeing a campus in which these sorts of crimes regularly occur reflects the preferred pedagogical outcome of these faculty. So to believe the broad myth, you'd have to believe that campuses wildly have embraced non-credible accusers as they have sat quietly back and sided with accused students in cases where victims actually had credible claims. There's no reasonable way to believe that. The second change that sort of undermines this myth is the transformation of the university bureaucracy, which has expanded in leaps and bounds over the last couple of generations, and particular types of university bureaucracies, diversity staff, student life staffs. The most readable coverage of this is a piece that Heather did about the California system. And these staffers, increasingly in university procedures, are the figures deciding sexual assault cases. One of the patterns has been, in addition to this single investigator pattern, has been the creation of specially trained panels that decide sexual assault cases, and the panelists are frequently derived from either the diversity staff or the student life staff, people who are ideologically predisposed to believe accusers. And yet we're supposed to believe, based on this, the sort of broad myth, that these figures who otherwise are very sympathetic to gender claims on campus in sexual assault cases have become so unsympathetic as to require federal intervention. And then the third is the broader issue of due process and rights of the accused. You can spend 5 minutes looking through the FIRE website. The campus disciplinary processes, even before 2011, were generally not favorable to the accused. There is no reason to believe that on this issue they would. And so it's really hard to imagine any institution in contemporary society for ideological, cultural, or bureaucratic reasons that would be more likely to believe any accuser in a sexual assault case, whether the accuser is credible or not, and would be less likely to afford meaningful due process to a person accused of sexual assault than the contemporary university in the United States. The idea that we need federal intervention to force universities to provide hearings to the accuser is almost beyond belief. The second foundational myth, and the one that I want to spend a little bit of time on here, is one that I often hear when I speak in sort of on background conversations with university administrators, and which sometimes has circulated into the public domain. It sometimes even appears in congressional debates. And this myth is as follows. Universities administrators admit, always on background, never publicly, that yes, maybe these procedures are unfair to the accused students, but they say, we had no choice. The Obama administration forced us to do this. We are unwilling accomplices in anything that has been done. Now, I've been very critical of the Obama administration. FIRE has, Heather has. The number of critics of the Obama administration on this issue, I think, has been depressingly small. And the administration, and I speak here as a Democrat who was a donor to Obama in 2008, the administration deserves every criticism that it has received on this issue. But, and this is a critical but, the denial of due process rights for accused students is not the sole fault of Obama administration policies. Universities have been willing and in many cases eager accomplices in this effort. And the way they have, and the way I think where the press in particular, with a handful of exceptions, has so failed the American public on this issue, has been a failure in coverage of this to describe the actual procedures that universities use. The typical reader is not going to go to a university website to look at the procedures to figure out what the universities have doing. And in the majority of campuses around the country, and in the vast majority of elite college campuses, which is really where this battle has been particularly heavily fought. Universities have revised their policies since 2011 to go beyond the demands of the Obama administration, and in many cases to go way beyond the demands of the Obama administration to treat accused students unfairly. And I wanted to briefly discuss 4 fairly representative universities in terms of these changes. The first is Yale. Yale was the first victim of OCR. They entered into a resolution agreement with OCR at about the time of the Dear Colleague letter in 2011, and as part of that, they revised their procedures. In the current sexual assault procedures at Yale, it is a 3-tiered procedure where the accuser gets to choose which procedure the accused will be subjected to. There is a formal disciplinary process, what passes for fairness at Yale, and it doesn't pass very high, in which there is a hearing. There is a second process in which the Title IX investigator, the person who is responsible for ensuring that Yale is not investigated by OCR, conducts the investigation herself. And then there is a third process called the informal resolution process. There have been 10 students since 2011 accused of sexual assault under the informal resolution process. All 10 have been found guilty of sexual assault. If there had been 1,000 students accused under the informal resolution process, all 1,000 would have been found guilty of sexual assault. This is a procedure, and I'm quoting from Yale's guidelines here, that has a goal to achieve a resolution that is desired by the accuser. Yale uses victim in its procedures, so that accusers can, and I'm quoting here again, regain their sense of well-being. Under the informal procedure at Yale, the accused student does not have the right to present evidence of his innocence. One student who was accused under this process has written that he was not even informed what the specific allegations against him were. This is essentially a reverse scarlet letter, where the student is branded a rapist, but is not punished by Yale. This is the compensation for the denial of due process. A letter is put in his file, and of course that letter would be discovered in any background checks that the student has to engage in. Yale promises only confidentiality, that word of this will not get out. But in one of these cases, word did get out. The former Yale quarterback Patrick Wick was found guilty under these procedures. Yale has never investigated who it was that leaked this material. Indeed, since 2011, Yale has never investigated an accuser for filing a false sexual assault report in any context. And a couple of months ago in a report, Yale issues these 6-month reports, said that it was not the appropriate venue in Yale's sexual assault policies to investigate a person who allegedly filed a false report. You can't get punished, essentially, at Yale for filing a false report. There is nothing in guidance coming from the Obama administration that says that schools must deny to an accused student the opportunity to present evidence of his innocence. Yale did that all on its own. University of North Carolina. They changed their policies in 2013, in part due to student activism. One of the chief goals of this policy change seemed to be to neuter the law that Samantha was mentioned, which had passed the previous year in North Carolina, that guaranteed to accused students the right to a lawyer. And so under the new UNC policies, the accused student can have a lawyer. The lawyer, however, can only see the evidence by traveling to campus him or herself, viewing the evidence physically in the office of the Title IX coordinator at UNC. The lawyer cannot photocopy or in any other way copy the evidence. Imagine a criminal justice process where the defense lawyer had to travel to the police department to look at the discovery file. And in the hearing, the lawyer can be prohibited from asking any questions of any witness at the jurisdiction of the chair with no opportunity to appeal this. So the idea was we have to have a lawyer in, so we're going to limit the lawyer's power in any way possible. Third campus, Occidental, which in 2013 had this outgrowth of sexual assault complaints. It had 11 and 10 the 2 previous years. In 2013, there were 60 allegations of sexual assault at Occidental, largely stimulated by this small group of faculty and activists who claimed that the previously existing policy was unfair to accusers. Under that allegedly unfair policy, Occidental said that while no always means no, yes may not always mean yes. So that is, a student who got affirmative consent from his later accuser could nonetheless still be found guilty of sexual assault. The Occidental's report came out a couple of days ago in their 2014 hearings. They dropped back down to 8. So this witch hunt atmosphere lasted for around a year. The 2 faculty members who pressed it went on leave in 2014, perhaps not uncoincidentally. There's nothing in Obama administration guidance that says that administrators need to stay indifferent to a witch hunt atmosphere on campus that targets their male students. This has had an effect. The current crop of first-year students at Occidental is 43% male, the lowest percentage that they've ever had. And then finally, Amherst College. I've been following these cases for around a decade. In the campus side of things, this is the single worst case that I have seen. This is a case in which the accuser did not turn over critical text messages sent from the night of the alleged assault that wholly undermined the story that she was telling. And in a process that was essentially designed to ensure guilt, all sorts of due process deprivations, the accused student was found guilty. He hired a lawyer, and a couple of months later, the lawyer uncovered these text messages sent to 2 different Amherst students on the night of the alleged assault that portrayed the assault as consensual, and that wholly contradicted what the accuser had said, not under oath, because college proceedings are almost never under oath, to the Amherst disciplinary process. The accused student then presented these text messages to Amherst. Amherst's response was that under its policy, the accused student lost the right to present exculpatory evidence within 7 days after the final judgment, and therefore the college had no obligation to consider this evidence. There is nothing in Obama administration guidance that says that colleges need to be indifferent to the truth and to refuse to accept exculpatory evidence later on. So in each of these things, these cases are a reminder that, I certainly hope that a new OCR revises its guidance. We desperately need congressional legislation to protect students. But in the end, universities are going to need further guidance as well. Thanks.
Thank you very much, and thank you, Heritage, for inviting me, and Ms. McClellan for setting up my accommodations last night, which were fabulous, so I hope to come back again. I'm going to step back from this discussion, and what Samantha and Casey have said is absolutely chilling, and I'm going to stipulate that the due process violations are outrageous. To me, it's patently obvious. There should be no institution that better understands the legacy of Western civilization is due process and protecting the rights of the accused. And the argument that is often made for this pathetic evisceration of legal standards down to the preponderance of evidence, the absence of cross-examination, double jeopardy, is that, well, the consequences are so trivial. Ridiculous, as Casey said. You have a sexual assault accusation on your record, it's over, even if you're not expelled. So this is a preposterous argument. But I want to stress instead just how weird the campus sex scene has become, including this very discussion about due process rights. In fact, we could have a fabulous panoply of due process rights for the accused. And that's part of the weirdness that I want to focus on today. I'm going to argue that we are seeing on campuses nothing less than sexual liberation experiencing a nervous breakdown. Now, let's remember the traditional norms regarding sexual behavior that sexual liberation decided to cast out the window as oppressive, especially to females. Here's the most radical idea, and it's risky to even say it, and I hope this isn't being telecast anywhere. Men and women are different. And they're especially different when it comes to expectations and responses regarding sex. Traditional understanding realized that men have a basically omnivorous, voracious appetite for sex. They will go after whoever is available in rapid couplings without a whole lot of emotional involvement or after effect. The norms of chivalry and courtship were developed to try to regulate and cabin the otherwise voracious male sex drive. It was also understood that females were different, that for them, sex usually involved a greater emotional involvement, a desire for stability and a relationship, and the norms of female modesty and, dare I say it, chastity, but we can revise that if that's too much of a red button topic, sexual prudence, were evolved to try and protect females from too aggressive an assertion of the male sex drive. And most importantly, in the traditional understanding, the default regarding premarital sex was no. Women could, at least with regards to women, now they could opt out of this default, and many did, but setting the default at no for premarital sex meant that you did not have to renegotiate every time a male propositioned to you. You could fall back on a collective understanding that these things are not really done. Well, what happened in the 60s? You got the sexual liberation coming up and saying, men and women are equal above all on the sexual battlefield. They will meet as equals mano a mano. We're getting rid of chivalry. We're getting rid of courtship. We are assuming that females desire one-shot hookups, promiscuity, with the same aggressive desire as males. And most importantly, the previous role of adults on campus, which was to enforce parietal rules that said, we're going to back up the collective norms and say that men and women are not going to be in the same bedroom together. The sexual liberationists said, adults out of the bedroom, stay out, let us handle this. Well, things didn't work out so well. 4 decades later, the liberationist regime is disintegrating in front of our eyes. The new order that has replaced it is a bizarre hybrid of traditionalist and liberationist virtues and values that allow females, preserves their right for promiscuous, unbridled sex, but allows them to revert to a stance of offended virtue at will. And it makes the male the exclusive protector of female virtue. And most bizarrely, after kicking the adults out of the bedroom, females are now asking the administrators to write and enforce rules for sex. This is absurd. Consider the sexual consent policy of Claremont McKenna College, which is influential. Occidental, for one, has adopted it. Paragraphs long, consisting of multiple sections and subsections, and embedded within an even wordier 44-page document on sexual harassment and misconduct, Claremont's sexual consent rules resemble nothing so much as a multi-lawyered drafted contract for the sale and delivery of widgets, complete with the definitions of the obligations of all, notice all parties, not both, we want to be inclusive here, and the preconditions for default. Quote, effective consent consists of an affirmative, conscious decision by each participant to engage in mutually agreed upon and conditions of sexual activity, the authorities declare ungrammatically. These are college adults, but they can't write. The policy goes on to elaborate at great length upon each of the, quote, essential elements of consent, informed and reciprocal, freely and actively given, mutually understandable, not indefinite, not unlimited. All parties must demonstrate a clear and mutual understanding of the nature and scope of the act to which they are consenting. Think here of signing a mortgage. And a willingness to do the same thing at the same time in the same way, declare Claremont's sex bureaucrats. Never mind that sex is the very realm of the irrational and the inarticulate. If you don't know that, try reading Euripides' The Bacchae, or Boccaccio's Decameron, or Ovid's Metamorphoses. But of course, such books are no longer allowed on college campuses. Doing something that you're not certain about doesn't make it rape, it makes it sex. Now, what is going on here? The affirmative consent standard that both Casey and Samantha mentioned is nothing less than a covert attempt to replace the default back to no. It goes further even than Victorian values because the female now is considered so helpless and so passive that she can't even squeeze out the word no. The male has to read in her unwillingness for her. In Claremont, as the Claremont McKenna policy says, the withdrawal of the consent can be based on an outward demonstration, not a word, but just an outward demonstration that an individual is hesitant or confused or uncertain. The male has to read this. Harvard is no different. Harvard allows females, after their drunken hookup sex, to unilaterally declare that they were assaulted by conduct that they silently regarded as undesirable. Recently, the American Association of Universities came out with yet another fraudulent survey that the press immediately ginned up again to the ridiculous 1 in 4 statistic that 1 in 4 women are sexually assaulted. And they also included in their definition of sexual assault lack of affirmative consent, which they define as somebody, and again, the grammar is so twisted, and I'm going to try and sort of ease it out, but going ahead while you're still deciding or without checking in, ignoring your cues to slow down. This is absurd, and most important, it's non-justiciable. There is no way that the campus sex bureaucrats can figure out after the fact whether the female was sort of sending some kind of nonverbal behavior that she was uncertain or still deciding. Policing these rules about affirmative consent and everything else requires a degree of voyeuristic prurience that should be beneath the self-respect of any serious university. It requires recapitulating every grope and every thrust after the fact to decide who was voluntarily participating and not. I'd like to take on the topic of whether there is a rape epidemic. I will just briefly recapitulate what Casey said. The statistics that are presented are ludicrous. This is a degree of crime that is unheard of even in the worst civil wars in the Congo. Moreover, every year, the stampede of girls to get into selective colleges grows more and more frenzied. Sophisticated, highly educated baby boomer mothers in Manhattan are now paying $200 an hour for coaching to get their little darlings into pre-kindergarten in the hope that 14 years later they will be admitted to Harvard. If there was a campus rape epidemic of the level we've been hearing about, you would have had a movement to create single-sex educational environments for girls decades ago. Instead, not only are girls becoming more and more the majority, they are graduating in higher and higher numbers without any signs of the trauma that the White House Council on Girls says is the result of college these days. and going on to lead successful careers. What we are seeing, however, is not a rape epidemic, but a regime of drunken, promiscuous hookup sex that girls are regretting and come through the administrations of Title IX administrators to define after the fact as campus rape. There are no clean hands in this squalid environment. The girls may not be rape victims, but the guys are behaving boorishly. They can avoid false rape accusations, which are rife, by treating girls once again with courtesy and respect and chivalry. Thank you.
Thank you very much. So we are a little bit behind, and I would really like to open the floor for questions immediately. So let me just say, when you ask your question, wait for the microphone. Please state your name and affiliation, and then, phrase your question in the form of a question. So.
I'm an attorney. I've been involved in working on some of these cases. Why don't the plaintiffs, especially with the state universities, name more of the university officials as defendants? This was done, I know, in the Amherst case. It was not done for reasons we've never been able to determine in the Washington and Lee case, or in a very similar case that's pending against James Madison University in Virginia, which is a state school. Why don't they go after all of these people? And why hasn't somebody named OCR as a defendant, as instigating this violation of everybody's constitutional rights, at least at public universities?
I'll take this one. So I think in a number of the complaints I've seen, there are administrators named. I mean, I think in the cases that involve 1983 claims, I'm fairly certain they have to, right? Because 1983, you can't sue the university. You have to sue officials who you're claiming acted in their official capacity. So, I mean, a number of them that I have seen do include university defendants, and in terms of why the others don't, that's not something that I don't know the answer to that. But with regards to OCR, I mean, I agree with you. I think that I think probably the wisest course of action against OCR is for someone to bring a challenge under the Administrative Procedure Act, alleging that OCR's promulgation of the Dear Colleague letter violated the Administrative Procedure Act by imposing new requirements on colleges and universities without the notice and comment that is required by the APA for such things. I think the interesting question is who has standing to bring those suits. And that's one that, I can tell you FIRE is working on that question, and it's something that we're very interested in. But as far as I can tell, the APA looks like it's probably would be the likeliest legal vehicle for reining OCR in on this issue.
So, Ash Scow, Washington Examiner. 2 questions. The first one's going to be for Casey. Can you speak to the numbers that we're finding from recently released Clery Acts about the unfounded reports across multiple college campuses? And then I think my next one's to Samantha. I've seen it used in one case. And I know recently there was the big Supreme Court case that dealt with disparate impact in housing. And I was just kind of wondering why more students aren't trying a disparate impact claim when it's very clear that male students are far more likely to be impacted by these due process.
I can answer that in one sentence, which is that unfortunately Title IX does not allow disparate impact. You cannot bring a disparate impact claim under Title IX.
Because they were charged with Title IX and the school, even if they're doing it through the court system to say.
Well, disparate impact isn't a cause of action. You cannot, the body of law on Title IX is such that you can't establish a Title IX claim by showing a disparate impact. You have to show intentional discrimination. That's what. For sex discrimination, not that I know of.
For under due process or something.
Not that I know of, no.
On the Clery Act, for this past year, for the first time, the Clery Act has required unfounded crimes to be listed in addition to reported crimes. And there have been three patterns. So a lot of universities in their reports have either not listed unfounded crimes, or they've just listed a general category of unfounded crimes, but have not said what the actual crime was. So it could be unfounded sexual assault or unfounded burglary. There have been some universities that appear to have defined unfounded unbelievably tightly. But there have been not insignificant numbers. Harvard's has gotten the most attention, thanks in part to Ash's report, where somewhere between 10 and 20% of the sexual assault reports in 2014 were listed by the college and university itself as unfounded. And that, of course, raises the question of whether any of the people who have made unfounded allegations in turn were charged with violating campus procedures. And to the best of my knowledge, there hasn't been a single case that's been filed, even though lying is against all college procedures.
So before we get the next question, I forgot to mention, Samantha Harris, we have outside, if you're interested in this online as well, we do have a legal memorandum that we publish here at Heritage that Samantha's the author of, which goes into a lot of what she talked about in her talk, and we hope to have other papers on the subject as well.
My name is Ed Bartlett with the Stop Abusive and Violent Environments. So for the last 4 years, the OCR has presented its 2011 Dear Colleague letter as quasi-regulations having the force of law. In the last 2 weeks, two Department of Education officials have said to Senate testimony that in fact these are not regulations, they are guidance, which changes the entire structure of how this issue is contained within the Department of Education. How do you see those admissions that these are guidance, this is a guidance, not a regulation? How do you see that playing out as this issue unfolds?
Yeah, I don't think it has any, unfortunately, legal significance. There's not some sort of estoppel you can have against them for their public admission. Certainly would look bad in a case if there ever were a university administration that were to stand up and challenge the Dear Colleague letter as if it ought to have been under the APA, subject to notice and comment rulemaking, and then you'd say, well, look, you said over here and you said over here, and it would look bad, but I don't think that it would, unless anyone, Samantha in particular, has a disagreement.
No, I mean, I was just going to add
it's great they said that, though.
That I unfortunately don't expect that it will have much impact because the climate of fear is such that universities are so reactive to OCR's prescriptions. I mean, just to take a similar example, in 2013, OCR and the Department of Justice entered into a resolution agreement with the University of Montana that at the time it called a blueprint for colleges and universities across the country. And one of the things that agreement required of the University of Montana was an expansive definition of sexual harassment that defined it as any unwelcome conduct of a sexual nature. And now that was something that FIRE was very concerned with from a free speech standpoint. And, we and other civil liberties groups put a lot of pressure on OCR and drew a lot of attention to the blueprint and to what we perceived as, its unconstitutional mandate. And they walked that back and said, oh, no, it's not a blueprint. It's only specific to the University of Montana. But, as part of my work at FIRE, I catalog university speech codes. And I can say that despite that walkback, many, many, many universities since 2013 have adopted the definition set out in that resolution agreement. So I don't think some sort of, ambiguous, conflicting statement that directly contradicts what the 2011 Dear Colleague letter actually says is going to have any impact on, universities' frenzy to comply with OCR guidance in this regard.
So if I could just very quickly add to that and zoom out for a minute, out of the education context. One of the benefits of the work that we do here at Heritage is the ability to take a bit of a global view. And this use of informal agency guidance as a way to avoid notice and comment strictures and regulate industry, as I said, in a fly-by-night manner, is not limited to the education context. There are many other areas, from cybersecurity regulation to other areas, and it's a huge administrative law problem that will take more of a global solution. And, settlements and informal guidance, and none of this is binding on other parties, et cetera, but people do follow it because there's an unholy relationship between the regulator and the regulated. So sometimes there needs to be something to cut, some hot knife to cut through the butter here. But Stuart, are you over there?
Stuart Taylor, question for Heather. My name's Stuart Taylor. Question for Heather or anyone else who wants to address it. You would think normally that when a Democratic administration engages on a reign of bureaucratic abuse and tyranny that does grave injustice, there might be some objections from the opposing party. We haven't heard very many. Why?
Because men are being disappeared in our society. Clearly, this is a very selective evisceration of due process, and it's occurring, I think, in the context where of the feminist university and the feminist administration, where men are simply regarded as not deserving or needing due process protections because they are presumed guilty unless proven innocent. So I think to expect any of us truly to always be consistent or ruled by principles is maybe overly optimistic to begin with, but in this case, the hypocrisy of claiming to want to beef up social justice protections in every other field except for campus rape is a predictable betrayal, I think, of neutral principles, but one that, again, I think is purely driven by the substantive values here, which is females really wanting it to have both ways, as I say, of bizarrely still insisting on the Emma Solkowitz mattress girl, sexual involvement, and then at the same time claiming to be so helpless that the male has to read their cues and protect the females from their own drunkenness when the male's drunkenness does not cancel his own responsibility. I mean, it's a bizarre double standard.
I think I got the word that we don't have time for more questions, so I appreciate you all for coming out. This will be put online. If you have any additional questions, please feel free to come up and talk with our presenters, but please join me in thanking them all. I think that was a very informative class.